Welcome to the In-Rem Podcast, where we discuss the law for real estate investors. Andy and Sean are both attorneys. Nothing said in this discussion should be considered legal advice. We're simply providing information and education. You should consult with an attorney in your state regarding any specific legal issue that you may have. Hey, good morning, everybody. Thanks for joining the show today. Today, our topic is business and estate planning for investors. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to this show, give us a like, subscribe to our channels. We're on Facebook, we're on YouTube. You can find us just about anywhere, and we appreciate you being with us. With that, Sean, give us a legal update.
So today I want to talk about the 5 necessary provisions to have in a real estate purchase contract. These will be focused on contracts that investors will use, but frankly, these provisions should be found in pretty much every real estate purchase contract. So the first thing that you're going to want in your contract is a cure notice. So, when you enter into a purchase contract, you're going to set dates by which certain things have to happen. One of those dates is the closing date. Well, there are times where things happen and you just simply aren't able to close when you originally planned, but you likely could close a day or two later. However, if you have a hard set closing date and that date is set in stone and there's something that's missing, maybe your wire transfer for the cash purchase was delayed, or maybe your lender had some difficulty in funding the loan, whatever the case may be, and you just need a few extra days. If you have a hard set closing date and you miss that, the contract's no more and it's canceled. However, if you have a cure notice, which states basically that if one of the parties doesn't perform by the time provided, then in order for there to be a breach, the other side has to issue a notice, has to state what the breach is, and then basically provide a certain amount of days. In my investor contracts that I draft, I like to see 10 days because that's, ample time to figure things out and close the transaction. The more standard purchase contracts have a 3-day close, 3-day cure notice time period. But you want to see a cure notice in that purchase contract, because otherwise you miss that closing date and it's done. You miss any deadline and that contract potentially is canceled, or you have an immediate breach.
Why do you like 10 days over 3 days?
Well, for investors, especially when you're wholesaling, the 10-day period allows for you to basically figure out, what went south. And normally what happens is, if you're wholesaling, what goes south is you have your end buyer. Your end buyer fails to perform, is unable to perform, and you need them out. And now you're going to have 10 more days in which to close. The key, though, in that circumstance is your assignment needs to very clearly and specifically state that if your assignee fails to close escrow within the time allotted, that they don't benefit from the cure notice, that they are out, right? There is no cure notice via the assignment. You want to make sure that the assignment's very clear on that you as the assignee, as the end buyer, you have to close by a set date. And if you don't, you're out. But you as the original buyer, the investor as the original buyer, if they have 10 days, they can then go find another assignee or end buyer and hopefully resurrect and save the transaction. The next provision that you want to see in your contract is a provision allowing the prevailing party to recover attorney's fees. And this is important for situations where you have a seller maybe that doesn't want to perform. And now you're going to have to pursue that seller and seek specific performance. Well, that's going to cost attorney's fees. There's going to be a cost to pursue that. Well, if you don't have a provision in your contract allowing for the recovery of attorney's fees, you may or may not be able to recover them. So for example, in Arizona, we have a statute, ARS 12341.01, which states that in any contract or any action arising out of contract, attorney's fees may be awarded by the court. However, I left out a term there purposely. it doesn't just provide in any action, it provides in any contested action arising out of contract, right?
Right.
So if the action is contested, then you might, at the discretion of the court, be able to recover your attorney's fees. But if you go and you file the lawsuit against the seller doesn't respond, doesn't answer, doesn't contest the lawsuit, and you end up getting a default judgment and you end up being able to purchase the property as a result of that default judgment, you don't receive attorney's fees because it was uncontested. The seller did not show up and answer, and that's required for it to be a contested action, so you don't recover your attorney's fees. Plus, you have discretion of the court, and a lot of times courts, may be more willing to exercise their discretion in a, transaction where the opposing party is a consumer, if you will. And so, the court may look at it and say, well, maybe the seller didn't fully appreciate the nature of the contract, what they were doing, that type of thing. Versus if you have a provision that uses the word shall and does not require it to be a contested action, but that the prevailing party in any action shall recover their attorney's fees, there's no discretion. And the law is clear, at least here in Arizona, that attorney's fees are to be awarded. The third thing that you need, and this is more focused on the investor transaction, although in the commercial real estate setting, especially where the buyer is going to be doing a lot of due diligence and entitlement work before they purchase the property, they're going to want this as well. But you want authorization to record a memorandum or affidavit of the contract. You want to be able to put the world on notice that you have a contract with this seller and that you are first in line to purchase this property.
You mean I can't just record the purchase contract and lien up the property?
No, unless your purchase contract, at least here in Arizona, we have a statute that is very clear on this, that basically states that unless you have written authority and approval by the seller to record that purchase contract or a memorandum or affidavit of the purchase contract, you can't just go and record something against the property. You're not allowed to do that. And you basically face damages and, penalties, attorney's fees for doing that. It's a pretty significant thing to run and record something without authorization. So you have to have authorization in your purchase contract to record a memorandum. The fourth thing, and this is something to be very careful about with investors, is you have to disclose your real estate license status if you're a realtor. If you have any ownership interest or any financial interest in the transaction, even if you're not representing any of the parties. But let's say I have an LLC, I own 40% of that LLC, and we're entering into a purchase contract. The buyer's going to be the LLC. Well, I have to disclose my license status. Even though I'm not the buyer technically, nor am I representing the LLC, nor am I representing the seller. I'm just an owner of the LLC. Well, you still in Arizona, you have to disclose that license status and make all parties aware of the fact that, there's an owner of the buyer who's a licensed real estate agent within the state of Arizona. And then finally, and this is becoming more commonplace, you need to make sure, and this is primarily for investors, you need to make sure that you have your state-specific disclosures within this contract. Here in Arizona, wholesalers have to disclose that they are wholesalers and that they intend to assign their interest in the purchase contract. So they need to make the seller aware that they may not be the end buyer. They may not be the one closing the transaction, but that they're a wholesale buyer. And there's other states throughout the country that require certain disclosures when it is going to be an investor that's, purchasing it or wholesaling it or assigning the contract. And those disclosures need to be made. So you want to make sure that whatever state you're transacting in or you're purchasing property in, that those disclosures are being made.
Interesting. Thank you for the legal update, Sean. With that, we're going to get into We're going to get into the substance of our program, and today we're talking about business and estate planning for investors. Our guest today, attorney Natalie Ouellette-Grice. Natalie is an attorney and owner with LCO Law, uh, and we're so happy to have her here today. Natalie, thanks so much for being with us.
Hi, everybody. And it's Natalia.
Natalia, sorry about that, Natalia.
That's okay.
Natalia, tell us about LCO Law.
So LCO Law, we started off about 11 years ago now. So it's past its first decade. We opened it up actually to serve the local Florida real estate investor community. We did a lot of title clearance transaction issues, and at the same time advising on business things that would come up, what was going to be beneficial for their operations. And as time progressed, as our clients started acquiring assets, we started offering the estate planning services, taking into account that they were business owners and that it was going to be a lot more complex than a traditional estate plan for a mom and pop. So
Natalia, tell us about what states rather you're licensed in. What areas or what states rather do you practice and focus in?
So I practice in the state of Florida, and for many, many years we did real estate litigation, estate planning, and business planning. And right now we're focusing just on estate planning and business planning.
I know you do some business coaching with Real Pro Coaching. Tell us a little bit about that.
So the business coaching comes into the side of really learning how to run your business, right? On the legal aspect, we attorneys create like structure and agreements to make sure that if things go sour, when they go sour, they're handled in a way that mitigates the cost to everybody involved, the time, the stress. But very few firms actually offer services that teach business owners how to run a business, right? If you come from the world of being a W-2 employee, you're not necessarily going to know how to run a business, right? And a lot of these investors come from a background where they're tired of being at their job. They want something new, they want something different, they want to be able to do something for themselves. And so they really need the guidance in how to think like a business owner. What are the things that are going to come up as a business owner? And you could think of it as kind of like a hybrid of coaching and consulting in running the different sections of a business, marketing and sales, and understanding financials, understanding how to manage people. That's our role.
So in business planning, I know sometimes estate planning and business planning can go hand in hand. But in business planning, one of the first steps I think oftentimes is missed is this idea of planning for growth. So much when we start our business, we're thinking about, okay, how do I make the bottom line from month to month? But you're not really planning on, you're dreaming about where you hope to be, right? But you're not planning for it. And in that planning for growth process, where does that start for you? I know that for us as lawyers, we often think it starts at how you structure what you are as an entity, your formation, and everything else. And we'd be interested to hear what you have to say about that. But what does that process really mean for you, and how does that begin?
So when I speak with a client, there's plenty of real estate investor hopefuls, right? They come to you with a dream. And so it really is about starting with, what do you want this business to deliver for you? What kind of lifestyle do you want it to give you? Do you want it to be something where it's just supplementing your income, infinitely, and you're okay with that? Is it something where you want it to completely replace your income and actually replace you having to be in the business, right? So it's very focused on, what does this person want? And then we work our way backwards from there, because not everybody's going to want the same thing. If you want it to be delivering, $500,000 worth of total owner benefits, then you've got some working back from there. What kind of profit margin do you need? What kind of sales do you need to be doing? What kind of marketing do you need to be doing to bring in that kind of sales, right? And honing in all of that into what we call a real proactive business plan.
Now, what does that look like from kind of the base level corporate structure? Is there a particular corporate structure you like, or is it all going to change depending on the business?
So it does depend Not so much on the business, but the person as well, right? Here in the state of Florida, we've got plenty of people who aren't necessarily U.S. citizens, right? So that's going to impact some of their corporate accessibility. No matter what, though, I do recommend that you have a separate legal entity for your business. Don't try to run this yourself, because you're putting everything that you own at risk, your personal assets, if something happens business related, your business assets, if something happens personal related. So if you don't have that limitation of liability, you're not starting off on the right foot. But different entities will work better for different people. So corporations, a corp might work a little bit better for somebody that's a foreign national. An LLC might work a little bit better for somebody that's a local. And then the type of taxation choices that they make also depend a lot on their status. And, do they want to broaden this out to provide additional capital, right? Make those capital requests, depending on the type of corporate structure. Some are going to be a little bit more attractive than others. So it's all tied to the goal.
Yeah.
Natalia, how are you?
Hi.
Good to see you again. All right. Hey, so I want to talk about the foreign nationals, because that's interesting. We don't do tons of that for our firm here in Arizona, but talk to us about what that looks like from a logistics standpoint. Let's say, somebody comes to you and, hey, I'm not a U.S. citizen. Presumably, I guess they have a tax ID number of some sort, or maybe they don't. I don't know. But they come to you and they say, hey, I'm going to start investing. I want to form, let's say, an LLC, right? Let's say, that they want to form an LLC. What does that look like logistically, as far as getting them set up, getting their EIN? Because that's always what I'm concerned about, right? Is, okay, how do I get this company an EIN if I have somebody that's not a U.S. citizen without maybe a social security number or whatever? What does that look like?
So foreign nationals can request tax IDs. And so It's not a social security number, but it's a tax ID, so that they can actually engage in business in the United States. And there are visas that are designed purely for investment purposes, right? A couple $1 million here. Depends on the business, right? There's multiple types of visas, but if you come in and you acquire a business and you invest at least a little over $1 million in the business, and you also manage to employ 10 people through the business, then you qualify for a specific kind of investor visa. So, right, real estate's big on one of the big sources of investment opportunities here. Acquisitions of commercial real estate are really attractive to foreign nationals. And so it's getting the tax ID and also helping them understand the tax consequences of it. Because if you're a foreign national, you're not only going to have different tax treatment as far as exemptions, allowances, that kind of thing. You're going to get different tax treatment on estate taxes owed. Very significant, different tax treatment. Here, for example, if somebody's a beneficiary of the estate, right, and they are a foreign national, so not a green card holder, not a U.S. citizen, that federal estate tax exemption is $60,000. It's not the $12 million we all hear about, 60 grand. So it's even more important to do very detailed estate planning so that you can minimize the tax consequences. Because imagine, right, you own a business here, every business is going to be worth more than that 60 grand exemption. So there's really some nuance in understanding the tax laws and how they apply to foreign national investors. The other thing is that a lot of these visas require business plans as part of what gets submitted to the applicant, to the agencies that are determining whether you get the visa or not. So some of the time we do work in creating the business plans for the immigration attorneys. I don't do immigration law, I just disclaimer there, right? But this is something that's a requirement. Why? Because the US government wants to know, how are you going to be investing this money? How is that business plan going to result in you employing 10 people? And how is this business going to pay for that too? Real estate, like I said, is such... it's really, really attractive for foreign investors, because even if the business doesn't end up working out, you can release the premises to another business. So there's that. Some opportunity out there for you wholesalers of commercial properties.
And so you do a decent amount of work then with foreign nationals, if they want to get up and running, you can assist them then.
Yeah, and I would say I have the background just because I have dual citizenship and I grew up in another country, so it kind of helps to have that language capacity with potential investors. And you just got to watch out to see what's going on in South America and Central America with elections, because elections determine how much interest there is in investment here in the United States for visa purposes.
Interesting. So when we're talking about corporate structures, this is something that I'm always approached about, and I'm kind of curious to hear your thoughts as far as growth. When we have these newbie investors coming in, they want to try to do it right, and they don't want to end up doing business for 6 months, realizing they've done it all wrong, and now they have to completely restructure, right? And one of the things that I'm always approached about, and so I'm curious kind of your thought on this is, hey, I want to be anonymous. I want to be out there, nobody needs to know that I'm behind the scenes. I want anonymity. And, I always have that discussion. Well, anonymity is not really asset planning, but, it's a deterrent, this and that. What's your thoughts? And do you see that as important to a corporate structure, the whole idea of anonymity for real estate investors?
I do think that if you're planning for substantial growth, like a substantially sized business, I'm talking, it's bringing in revenues of over $1 million a year, right? For a small business, that being substantial, I would say at that point, anonymity is something that maybe you want to take into account, just because the more assets that you have, obviously, the greater the risk is overall, right? You've got more investment properties, you've got more potential lawsuits from slip and falls, something happens to the roof, that kind of thing. So as your assets grow, your risk grows. But anonymity, as you said, right, it's a deterrent. It's not the safe all protection against being sued. If somebody feels like filing a lawsuit, they'll file the lawsuit. Whether that lawsuit has merit is an entirely different thing, right? Our job, I believe, as like corporate attorneys that advise investors on how to protect their assets is, what deterrents can we put in place in addition to like practical processes that are going to minimize the risks to your properties, right? So, yes, you can have it held by a trust or held by a land trust, or have it held by a professional trustee, so that people don't see that, you own this particular parcel of land, or this business that owns parcels of land. But ultimately, it's, like, are your properties insured? Are you vetting the people
Right.
that are the contractors on these properties, right? Are they pulling all the permits? Are you making sure that the property is maintained? Are you inspecting your properties? Like, all these things have to play in together to really reduce the risk of substantial, impactful, painful litigation.
Right.
Natalia, talking about the growth part of the planning aspect of a business, are there a particular set or core group of agreements or contracts that you think are foundational, that the standard business ought to think about having or doing right from the beginning?
Yes. So, I mean, no matter what your business structure is, right, you've got to have an agreement that dictates how the owners are going to behave with each other. Whether you're calling it an operation agreement because it's a limited liability company, the bylaws if it's a corporation, right? Trust, a well-drafted trust agreement. There's got to be something that addresses what I like to call the 4Ds, right? So it's going to address the disability of the owners, the death of the owners, disagreements between the owners, and divorce between the owners. So these are like the basic things that need to be addressed. Obviously, it should also talk about, what kind of a tax plan are we going to follow? How do we sell shares? Is it open? Is it something that anyone can purchase, membership into this entity, or are we going to be a little bit more restricted about it? What kind of behaviors are we going to allow from the managers of this entity? Is it going to be a manager like, director based kind of a thing, or is it going to be all all owners on deck, everybody gets to make that decision kind of a thing. And this is something to consider for business owners that have multiple partners, right? Some partners are kind of more money oriented. They want to sit back behind the scenes. Other ones really want to be in the game and making decisions, right? Depending on the state, there are certain states that allow voting versus non-voting stock or shares. And so that's something that should also be considered in these agreements. But that's definitely foundational agreements there. If you've got multiple owners, you should have buy-sell agreements, right? What happens when this happens? Because it will happen, right? Somebody and things like that help supplement the buyout, so you can buy back shares from another from your partner if they go through the divorce, or if they pass away, so that you don't have to dealing with their heirs as co-owners now with your entity.
I think one other issue I'm thinking of, and I think lawyers miss this all the time because they don't really think of it as part and parcel of giving legal advice. I think you probably do working as a business coach, but what about a business plan, marketing strategy, those kind of things? How are you able to help, and what do you do in that regard?
So that is something that we, no matter what, you will get a business plan included in working with us to create a corporate entity. And why? But for that same reason, right? Like, you can have hopes and dreams, or you can actually have a plan to get somewhere. I may say all day long that I want to go to Las Vegas, right? But if I don't actually put the location into my GPS, put in where I'm at right now, I'm not going to know how to get there. And that's what a business plan is, right? It says, here's the goal that we want to get to, and here's how each and every one of the parts of our business to work toward the goal possible. Here's what we're going to do to market. Here's how we're going to goal. Here's how many people need to get to that goal. We're 168 hours in a week. There's not so much that we can handle ourselves. So we need to have people in place, and the right people for the roles. We need to examine our financials. So a business plan should include what financials should we be looking at, and how frequently should we be looking at them, to see if things are matching up to what we put in. And obviously, kind of like the other big part of a business plan is, what are our processes? What are our processes to get here? What connects, marketing to sales to our people to that entire, it's a nice, clean, smooth line that follows through. And that's what a business plan is. A business plan isn't something that we create once and kind of ignore and never look at again. Just feels good kind of a thing. A business plan is definitely something that you need to have in place if you plan on growing at all as a business owner.
So let's talk about systems. So we've put together kind of the foundational structure of the business. Now we're really talking about operating, and what would you say are, well, first, how do you help businesses with establishing good systems? And explain for our listener what kind of systems make a business and what kind of systems break them.
So very simple definition, right? Like, a system is a set of processes that can be repeatable, right? That are going to produce the same kind of result. That is an ideal system. So a system that's going to make your business is one that, no matter who you put in the role, that role is going to get accomplished in the same way, going to produce the same result, right? It's that consistency and predictability. A system that breaks your business is a system that's inconsistent, or it's poorly fitted with your actual business goal, or it's poorly fitted to your ideal client, right? If you're a real estate investor, you may have an ideal client profile that's all dealing with like luxury clients, right? And so your systems better match up to the expectations of a luxury client. If for example, your business is one in which you are wholesaling to people whose family member has died, right? Having to do with probate and acquisition of property through probate, you need to make sure that your system aligns with that and isn't, matched up for something completely different, like a flip. So that alignment or lack of alignment is what makes or breaks a system.
So one of the questions that I had, and I think maybe you answered it to some extent, but we have a lot of real estate investors that listen to this show. That's what the show is heavily about. And whether there's a particular set of systems that you would recommend for the real estate investor. But it sounds like it really depends on what the investor's focus is within real estate, whether it's, like you said, a fix and flip, or whether they're wholesaling, or what their strategy is. Is that true, or is there particular systems that tend to fit with all?
So I would say for the vast majority of real estate investors, right, whether it's a fix and flip or you're doing wholesaling, if it at all involves sales, your system needs to take into account interactions with the title company. So your system should have, title companies, at least 3 of them, because you never know, right? One might have some issues, another one might not take your type of transaction, but you need to know this is the type of title company that's going to accept this type of a deal, this type of transaction, right? Their underwriters are comfortable with this. So you've taken the time to interview them, to know their process and learn their entire process from beginning to end. How do they like to receive the contract, right? What information do they require from you for the buyer, seller, and buyer, all that information? What do they need in advance? About how long does it take for them to get back searches from their underwriter, if their underwriter is the one doing searches and they don't do searches in-house? You need to know all that info from beginning to end so that you're not surprised in the middle of a transaction. So your sellers are not surprised, because it's knowing when and how to communicate that keeps things running smoothly in these transactions where you've got multiple players. You just need to have that. And so any investor that deals with sales and flips and wholesaling, you must have a system that incorporates and takes into account the entire length of the title company process that you've chosen to work with.
Natalia, I'm a huge fan of policy and procedure manuals. So I have a number of real estate broker clients. And of course, here in Arizona, the Department of Real Estate requires any broker that has, I believe it's over 2 licensees employed with them, they have to have a policy and procedure manual. So I've worked with them in drafting those. I've worked with other businesses outside of the real estate broker realm and putting policy and procedure manuals together. But I'm also surprised that when I see a lot of businesses who have employees or independent contractors and they have no policy and procedure manual in place whatsoever. At what stage, and what type of business for that matter, do you think a policy and procedure manual is appropriate?
I think a policy and procedure manual is appropriate for any business in which you plan on it being more than just you. And ultimately, with succession planning, you need to have it in place too, because somebody's going to have to replace you for that business to keep going, right? But if you have an independent contractor, if you have a part-time employee, if you have a full-time employee, you need to have that in place. You need to have the guidance that says, here's how we hire people, here's how we retain people, here's how we discipline people, here's how we fire people. Here's the things that we make sure that we don't ask of employees to violate state and federal laws, right? Things that we discuss, that we can discuss if somebody's leaving and going elsewhere, things that we can't discuss if somebody's doing that. But also, part of those policies and procedures, I think in this day and age, considering how much people enjoy video and audio, you can convert into that. It's a lot easier for people to digest than having just a written policies and procedure manual, which is just going to kind of sit and collect dust. I think it's a little bit more interactive if you have, yourself, right? This is what's important to me. This is what's important in hiring. Here are the kind of people that we want on our team and that kind of thing. Or here's our company incentives, and just update it and do it as videos. And that's a great way of actually creating the procedures for your business, for the steps of here's how we have a sales conversation and that kind of thing. Record yourself in the situation. That recording is going to be so much more instructive in training your team on how you want things done than words. It just works.
That's interesting that you mentioned that. I'm still kind of old school, and so I want to see it on paper. But our firm, for example, we'll have our firm meetings monthly, and as part of that meeting, we might have a training. And whenever we're going to have the training, we always whoever's doing it, whether it's me or another attorney within the firm, we'll record that and then we'll store it. And so that people can go back. But so the idea of, well, instead of a written policy and procedure manual, just have a bunch of, training videos, that may be more effective, right?
Yeah. I wouldn't say in lieu of, right? I would say like
in lieu of,
together.
Yeah. Okay.
And one of the great time savers that's out there for people is that if you record it as a video, there are so many AI options available out there that will transcribe it for you and can translate it as well. So if you have employees in different regions, or you have a virtual assistant that speaks both Spanish and English, it's also good to have that information for them in dual languages, because sometimes the terminology doesn't translate if you don't train them on what specifically does this term mean. Like, for example, here, Florida, right? Huge Spanish speaking population. If you've got team members that speak to both Spanish speaking, property owners, that's who you're interested in, or English speaking, or even Creole speaking, right? If you've got the training paperwork in place in all of those languages, it's going to make it that much more smoothly and reduce miscommunication. So videos go along with your written manual, but if you start with a video, you can turn that into a written manual that much faster because of AI.
Talk to us about the importance of employment agreements and independent contractor agreements.
Oh, yes. This is big. I would say have that as well, like as one of your initial, I don't care if it's just you, like you need to have that, but not just employment agreements, which, delineate the terms of like what this person's job is, what are causes for which they're definitely going to be terminated, how long the term of employment is, whether they're allowed to poach coworkers, if there's any like non-compete agreements, if they have specialized skills, those kind of things. You definitely want an employment agreements. Independent contractor agreements, right? You want to make sure that you are not directing their every move, specifying how they dress, specifying how they show up, providing very detailed scripts on how to do the thing, right? Because then you're an employer,
right.
and you're just calling them a 1099-1, but you're going to get in trouble. Agreements that go along with this that you should have are like waivers. So one of the big things for real estate investors, right? They have runners. They have people that go and take photographs of the property. They have people that sometimes go into the property and kind of see what the condition is like. So you might want to have them sign waivers of like, hey, if you trip and fall over, there's hoarder stuff. You're not going to sue me for it. You disclaim and waive any liability. You are, like buyer beware, enter beware, right? So you want to have those supplemented as well. And then as far as like employment agreements, you always want to make sure that you're discussing that with an employment attorney in your state. So I'm not an employment attorney. I encourage my clients to go and speak with an employment attorney to supplement their agreements to make sure that there's nothing off or some change in the law that's going to require a different kind of wording behind the scenes. And the same goes for the independent contractor agreements, right? It's like, go and get yourself updated, because as a business owner, you need to be aware of what regulations are being imposed upon you as an employer.
Are non-competes as difficult in Florida to enforce as they are here in Arizona? They're very difficult in Arizona. You have to be, very careful not to make it over broad, and you could end up losing the whole non-compete if you don't draft it right. Is that the same in Florida as well, or
it's similar?
A little bit more friendly? Yeah,
it's similar. Like it really is. Non-competes just for any regular person isn't going to cut it, right? They really do have to have specialized skills. It does need to be limited to a reasonable region. It does need to be limited for a reasonable time period, right? That's not going to make it overly burdensome for this person to have a living. But what is more enforceable is that like the non-poaching agreements, right? Non-solicitation of employees, non-solicitation of clients, unless you're in a regulated industry like us, where clients are free to go wherever they want to go. We can't have those non-solicitation of client agreements in the legal industry, at least not here in Florida. But yeah, it's just, be reasonable and practical if you're going to have these limitations put in your agreements. Reasonable and practical, fairly enforceable. I wouldn't go beyond a year in any non-compete agreement here if you want it to be enforced.
Right. That's pretty much the same in Arizona. I receive this request all the time, and I don't do it because I do think it pushes the the relationship from a contractor to an employee, but what's your take on non-compete provisions, not non-solicitation? I'm talking actual non-compete provisions in an independent contractor agreement.
So, I mean, I think like with independent contractors, right? You are essentially entering into a business agreement with another business. That's how you need to see it, right? So businesses are going to compete. At this moment in time, you might have a relationship in which you kind of like each serve that particular target client in a way that's parallel and cooperative. But who's to say that this person doesn't, see your business style or your business model and go, I want to do that, right? And again, they're an independent contractor, so the ability to direct them and govern them like you can with an employee is really, really limited, right? You don't want to pass that line, and then you've got self-employment, or not self-employment taxes, but you've got like the employment taxes that you've got to take care of at that point, and the penalties that are associated with it, and everything else that goes along with it. So if however, right, this is an agreement in which you've both heavily negotiated and with you've both got your lawyers and you're both okay with it, I think taking into account that kind of history, it might be more enforceable. But you really do need to have it be not quite a contract of adhesion for that to stick.
Right. And I think you bring up a good point too. If it's a business to business independent contractor agreement versus a business to individual, so the individual's the one serving as the contractor, then I think the non-compete is probably not going to be a good idea, because you're pushing an individual, you're putting more control over an individual than what I think you should over, a contractor, versus business to business, as you point out. Hopefully that's more well negotiated, and if they're sophisticated players, yeah, I guess they could agree on non-competes amongst themselves, as long as they're both represented by counsel and things like that is probably enforceable. But interesting.
I like to have the conversation about employment versus independent contractor agreements, because it forces the conversation. Because in my experience, especially new businesses and they've always decided they want the independent contractor relationship. And why have they done that? Because they perceive it as being cheaper. It not necessarily is the case, but they perceive it as being cheaper. And in reality, they basically have in mind an employment relationship that they're wanting to structure.
Yeah.
So I like to discuss how to form those agreements, just so we can begin having that discussion, and so they don't go down the wrong road in entering into an employment relationship and then paying them as an independent contractor. Natalia, let's talk about succession planning and succession planning strategies. For our listeners, we just use the term interchangeably as attorneys. We know what it means, but what is succession planning? How should our listener, the typical real estate investor, business owner, understand that term?
So I think a simple way to present the succession planning idea is planning for when you're not there, but you want your business to continue.
Okay. Does succession planning have to require, so it's a lot like estate planning. It's planning for maybe our death, or maybe some other cause, but like you said, planning for us not being there. Does it necessitate or require our own individual estate planning?
I would say that to do it right, you definitely need to have your own individual estate planning, right? Because a business is an asset, right? Right. And when you're a business owner, you need to make sure that as one of your assets, it is taken into account in your personal estate plan. Because say you have a succession plan in place, you've decided and you've put in your paperwork, right, that like your partner is going to get to purchase the interest from you if you pass away, that kind of thing. But that whole part can get stalled if you don't have an estate plan in place that keeps you out of the probate court process, right? So now you're kicking your business partner into having to wait for all these court orders to come through to enact that business succession plan. And that can be years, right? And the big thing people don't realize is the more assets that you have, essentially the more complex that probate case can get, which is the bigger reason why you want to keep yourself out of probate as much as possible, and why people with, real estate businesses almost always go toward the route of, well, let's get an estate plan in place that's going to keep me out of court and keep my family out of court and keep my business partners out of court, because it'll just become so complex that you can lose a lot of the value of those assets in stalled litigation, the processes, the checks by the court. They want to see this, they want to see that, they want evaluation. All those things you could avoid if you do both business planning, like succession planning, and your estate planning concurrently.
Well, I think that's right. So many clients that I speak with, they see estate planning as who gets my stuff, right? It's what's going to happen to my stuff, and they don't realize or appreciate typically on the front end. A lot of this is an authority issue. The law depends, banks depend, uh, third-party purchasers depend on my ability to sign on my behalf when I convey real estate, when I act on behalf of my company. And when I'm not there, all of a sudden there's this giant void of who can act, right? And
Yep.
if I haven't put the proper documents in place, and what you're indicating is we're now relying on courts to appoint the people who are now going to act on my behalf, and there's a giant waiting period, and that may be okay for a family that's maybe just waiting to close out an estate, but for a business that's operating day to day, that needs to make decisions on the fly, it can be incredibly intrusive. So, at what point in the business life cycle do you typically recommend your clients begin preparing for this?
I'd say from the very beginning. And I think of it this way, like I explain it this way for a client. If you are coming in and you're starting a business, right? Your role as a business owner is to be the owner. You don't have to be in operations, right? Your job, you have one directive, right? The business has to make a profit. That's your directive as the owner. The rest can be done and delegated by everybody else. So treat it as a project of delegation from the very beginning. That's also planning for growth at the same time. But if you make it very easy from the start of like, when I'm out, like, here's how things get done, here's who's in place. This person, I'm going to train on this aspect of a business. I'm going to cross train this one on that as well to make sure that like there's no holes there. This person, and also potentially this person, I trust to be able to manage things. They're financially savvy, they understand. I'm also going to train them in operations so that they get that. This one, I'm going to make sure it understands like the HR aspect, right? Managing the people. This one's really great at systems processing, and just cross training as part of succession from the very beginning, right? So that when you're out, and it could be you're out on vacation for a month, it could be that you're out because you were in a car accident and are incapacitated, it could be that you pass away, right? If you do it from the very beginning, it makes it that much easier. And all of this relies on having systems in place, systems that have designated people, designated responses, designated processes, and ultimately that's what creates the value, the real true value of your business when you decide that you want to sell it, or when you decide to pass it on to your children, right? That value comes from what makes your business run like a machine.
So you're having this conversation on day one. Hey, we want to start this business. Have you thought about what's going to happen if you're not there with the business? Have you thought about
Mm-hmm.
your own estate plan, the growth systems, and everything all together?
Yep.
What So I know that in typical, a buy-sell agreement is typically part of, in some form, a business succession structure. And oftentimes, certain insurance products are used to help facilitate buyouts and everything. Do you recommend particular strategies with regard to insurance products, and how that works, or is it just going to depend on the type of business and what they want to do?
So I mean, obviously it depends on like how they want it to be passed on, right? Some people are going to want to leave it to a key employee. Some people are going to want to leave it to a partner. Many people want to leave it to their adult children that kind of have a similar mindset, like the business, like the industry. But you definitely need to have your insurance partner in place there, right? Explaining what's available, what kind of life insurance policies could fund this. Do we need key man insurance in place in case something happens to that very important person that knows all about management operations, and something happens to them? You need to be able to hire their replacement quickly, right? And with sufficient incentives. So that's another kind of like policy for succession purposes. It might not be ownership succession, but it is like business operations succession. And the reason why you want to supplement these agreements with insurance is, as you know, right, we don't want to drain the actual operating capital from the business. We want the business to be able to continue to pay what it needs to pay to get things done, to grow. And so life insurance is a great way of doing it, which is also why it's important to start early, because life insurance policy rates are very cheap the younger that you are, almost impossible to get after a certain age. And so that's something that should be considered.
Natalia, what about disability insurance? How important do you think that is to, the succession planning, especially, and you use the term key man insurance. I mean, there are some employees that are integral to a business, whether it's an owner or just, an employee. And if they were to become disabled, what would the business do and how can it protect itself?
So that's part of the reason why I talk about cross-training, right? If you've got more than one person, you need to make sure that they're understanding how to do this other person's job and why this other person's job is important, which is why we've got all those video and written processes and procedures for these things. Disability insurance can be used for a number of reasons, right? Not just to take care of this person if something happens to them. It provides an incentive for being part of the business if they know that they're going to be supplied with disability insurance. Overall, though, we need to remember that every role is replaceable. And so I would say, more of an emphasis on not so much the insurance foundational perspective, but having really good clarity as to what these roles require, the kind of individual that needs to be in those roles, and just always be recruiting. As an owner, you should always be recruiting for the roles, because people aren't just going to, be unavailable because of disability. They might have to move for a spouse. They might decide that they want to go into an entirely new career and industry. You can't hold people hostage in your business. The only person that's hostage in your business is you, the owner. And even you can get out of that. So you've got to see it from the perspective of these roles. Who are the great people that would be, potential for these roles, and talk to your referral sources, talk to your overall community of other business owners. Who do you think would be great to fit in this role? When you're having conversations with somebody at the hotel that you're staying at or the car dealership, if you see something that's like a little light that shines and you say, this person would be great for this role, take their info. Start cultivating that from early on so that you're not in a terrifying place when that person decides to leave or when they become incapacitated.
So what about businesses that have multiple owners? And a lot of small businesses, at least when they're first starting, they are the owners, right? So, maybe you have 3 owners and they're expected to work day in and day out within that business. And depending on whether it's a partnership tax structure or an S corp, you're paying them, but the bulk of their compensation is from the profit of the business, right?
Mm-hmm.
And as an owner, especially say you have an S corp, as an owner, they're entitled to whatever profit percentage that they own. So all of a sudden, though, one of those owners ends up disabled and they're not able to work in the business, yet they're still an owner. And so you're now having to pay them 1/3 of the profit, and you're receiving, sounds harsh, but you're not receiving anything in exchange, right? They're no longer working within the business. And now you're having to figure out, okay, how am I going to replace that person? What does that look like from a succession planning perspective?
So with your succession planning agreements, I mean, you definitely need to make determinations as to, does the business have the ability at the point that somebody becomes disabled, right? Do they have the ability to buy their share? Do the other members have the ability to buy their share? Within what time period can they buy their share? What valuation rates are going to be used to buy back those shares, right? Because the reality is that if you can buy out their interest, and the faster that you can buy out their interest, the better it's going to be for the business. It's harsh, yes. But each individual owner also has the responsibility to make sure that they are covering themselves in the event that something like this happens, right? That they can no longer physically work. They've got something in place to take care of them individually as a person, so that they can continue to have a reasonable quality of life. The business, though, needs to operate always from the perspective of, this is a business. We need to make sure that it's a profitable business, and we need to have options to get rid of actors that are not profitable in the business. That includes co-owners who have become disabled. So it might come off a little bit harsh, but you do have a duty and an obligation as a business owner to think in the perspective of, I'm here for the business to make a profit. And if you need to be able to fire yourself as an owner, that needs to be there as an option. So all these agreements need to say what happens in the event of not just disability, but like retirement. What does it mean for an owner to retire, right? If they're not contributing their physical labor anymore, can you buy out their interests, right? Can the company buy out their interests? And then figuring out those valuations in advance is really important. Otherwise, it gets very expensive if you leave it for, the day that they decide to become retired or the day a disability happens.
Well, and that's interesting that you mentioned retirement, because to me, that seems to be a major, number one, concern, but also gap in planning for a small business, right? I mean, if you own a small business, you're always thinking, well, what's my retirement plan? What does this look like? Can I save enough to be able to retire? Is Social Security going to provide enough for retirement? And I think a lot of small businesses don't think that far in advance and say, okay, how do we make it so that this is something that we can utilize now and we can support our families with, but we can use this later on as a retirement vehicle so that, someone else can come in, fill my role, but I still can receive some residual income from the business. And I think that's a major lack of planning, and a gap that a lot of business owners don't consider.
Mm-hmm. Yeah, when we go into business ourselves, it's often the last thing that we think about, right? If we're somebody else's employee, we daydream about retirement.
Right.
We're our own boss, right? We don't want to fire ourselves, but retirement is kind of like that. Hey, let it go. Other people do the operations better than you. Other people have more energy than you. And it doesn't matter if you decide to retire at 67 or if you decide you want to retire at 50 from your business. You've got to leave your business an opportunity, and especially if you've got partners, to buy out your interests so you're not a drain, particularly if you were supplying a lot of the work, the hands-on work of the business. It's again, the business needs to be able to replace you. And so there are agreements in place where you can, for example, get bought out and there's a note with a term, right? So then you're essentially, your retirement is what you're receiving from this note that the business owes you, or that fellow business partner that's bought out your interest owes you for purchasing and acquiring your interest. There's options like annuities that you can, have the business own, and then that annuity takes care of you, and you're out. You're no longer, hands-on. There's life insurance policies. There's all sorts of different products, but it's good and to know your boundaries. And I know that as a business planning attorney and estate planning attorney, I'm not an insurance agent. So I want to have those conversations with the agent and my client to make sure that they're selecting the right plan that's going to work and match up what their expectations are of, cashing out.
Natalie, thank you so much for being with us. We really appreciate it. Tell our listeners where they can find you.
All right, so different ways to find me. I am on YouTube. You can look me up by Natalia Ouellette-Grice. So we have a YouTube channel with hundreds of videos on estate planning, business planning, and real estate investing. There's also facebook.com/LCO and you can email me at Natalia, so that's Natalia @LCOLawFL.com.
All right. Again, thank you so much. We really appreciate your time. Go find Natalia, YouTube, Facebook, email, get a hold of her. We really appreciate everything.
Thank you, Natalia.
All right. With that, that is our episode for today. Next week, we're talking about top tax planning strategies for the savvy real estate investor. We have as a guest CPA Dustin Griffiths. We'll see you next week.
Have a good day, everyone.